Welcome back to Law Stash Channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Imagine if you were flying into the United States and went through the airport checkpoint, or if you're coming to the United States through a port of entry on your vehicle, and Customs and Border Patrol agents or Department of Homeland Security install a GPS tracking device on your vehicle without you knowing, or put a tracker in your belongings without your consent, and then track you without a warrant for the next hours or even days. That's exactly what happened in a 2017 case in the Central District of California, and I know that practice is ongoing, as I recently had a case that was very similar to the one in the Central District. This video begins a multi-part series that I will call Searches by GPS Tracker that are initiated at the border.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
In 2017, Border Patrol agents installed 2 GPS tracking devices on a truck and trailer that entered the United States. For the next 33 hours, the agents surveilled the vehicle as it made its way to Los Angeles. Now, this installation was without a warrant and without consent. About 20 hours into their surveillance, the officers also began a physical surveillance of the vehicle. Sometime later, they saw the individual stop and meet with some other people, and there was an exchange of a duffel bag. Officers suspected that all of these individuals were part of a drug trafficking organization bringing in cocaine into the United States. Now, officers briefly detained the individuals and searched the duffel bag. They found 15 4-pound packages in those duffel bags. But instead of cocaine, the substance turned out to be sugar. The officers released the individuals, and about 8 days later, they arrested them as they tried to enter Canada back from the United States. This revealed an interesting policy in the Department of Homeland Security. According to a declaration from the Assistant Director of Homeland Security at the time of this criminal prosecution, the DHS GPS policy allows for the installation of a GPS tracking device on a vehicle at the United States border without a warrant or individualized suspicion. Because the warrantless tracking and monitoring policy is limited to warrantless GPS monitoring to 48 hours, DHS deemed it acceptable because individuals have a significantly reduced expectation of privacy in the location of their vehicles at the border. This 48-hour rule also purported did not apply to commercial vehicles like semi-trucks whatsoever, according to the Assistant Director. A significantly reduced expectation of privacy in the location of these vehicles applies. Now, the Fourth Amendment protects you against unreasonable searches and seizures, and we know that protection does not apply only to physical intrusions, but also it protects your expectation of privacy as long as the society deems that expectation a reasonable one. And generally speaking, officers need to have a warrant before they conduct a search or seizure. Now, there are exceptions to the rule, and one of the biggest exceptions to that rule is the Border Search Doctrine, which predates the Fourth Amendment, and it allows officers to conduct virtually all searches without a warrant at the border. That is because Congress has inherent power to enforce its immigration laws as well as regulate interstate commerce. And thus, most searches at the border do not require a warrant. So the question, of course, becomes, in this case, whether a warrant applies or whether the Assistant Director of the DHS is correct when he says that warrants are not required because this is a border. I want you to think about that question, because if you think about it, the installation of the GPS tracking device occurs at the border, but the search itself, the monitoring, the surveillance occurs outside of the border, within the United States. So in this multi-part series, we're going to discuss the Fourth Amendment, the application of the Border Search Doctrine, and then we're going to focus on the Central District case, which, to my knowledge, is one of the few cases that has a published decision from a district court judge that deals and answers this question. I hope you enjoy this short series, and if you like it, please give it a thumbs up. If you're watching this on YouTube, subscribe and hit that bell notification button so next time I post, you'll be first to know. If you're listening to the podcast version of this recording on Spotify or Audible, give my podcast a 5-star review rating. And if you want to support my channel, consider going to lawstash.com and checking out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and other items. Thanks for watching.